Good afternoon, and welcome to ASA's safety webinar on reasonable suspicion. I'm Michael Place, Safety and Compliance Officer for Dakota Supply Group and the Chairman of ASA's Safety Committee. Each month, the Safety Committee publishes articles and toolbox talks on a variety of safety-based subjects. These can be viewed and downloaded from the ASA website at www.asa.net. Also available on the ASA site are recordings and downloads of previous webinars. All of these items are available free to you and the public. To view these resources, look for the Safety Resources link on the ASA homepage, which is located at www.asa.net. If you have any problems, contact Jim Kenzel at the ASA for assistance. At this time, I'd like to draw your attention to ASA's supplier partners being shown on the screen. They are very important to the work that we do. The Safety Committee would like to thank them for their industry leadership and for supporting our committee and these webinars. This webinar is being recorded for later viewing. Everyone that registered for the webinar will receive an email notifying them when and where the replay of the webinar is available. Attendees will also receive an emailed link to its location. All attendees are in mute mode. To submit a question during the presentation, you can enter it in the chat window. Before you send it, be sure your setting is set to send the question to our organizers and the panelists so we can see that question. Questions will be answered at the end of the presentation as time allows. Also, an FAQ document with all questions and answers will be posted on the ASA site along with the replay of the webinar. Other related documents will be posted in this location as well. I would now like to turn our attention to today's event. Today's webinar is presented by Conn, Maciel, Carey Law Firm. CMC is a law firm focused on labor and employment, workplace safety, and litigation. They provide strategic guidance to a variety of individuals and institutions ranging from employment counseling to managing government regulatory investigations. They are an expert on the challenges facing workplaces throughout the country. Today's presentation is Reasonable Suspicion. Our presenters for this webinar are Gelb and Dan Deacon. Gelb is a partner of Conn, Maciel, Carey's Chicago office. He specializes in labor and employment and OSHA litigation. Mr. Gelb represents employers in all aspects of the employer-employee relationship. He has extensive experience litigating equal employment opportunity matters in federal and state courts, having tried a number of cases to verdict, and defending employers before the EEOC as well as fair employment agencies across the country. Dan Deacon is an associate in the Washington, D.C. office of Conn, Maciel, Carey, working in both the labor and employment and OSHA practice groups. Mr. Deacon advises and represents employers on a wide range of employment-related issues, including wage and hour disputes, claims of discrimination and harassment, compliance with Americans with Disabilities Act, the Affordable Care Act, and the Family Medical Leave Act. A full bio of the presenters will be posted with the webinar documents on the ASA site. I'd now like to turn the presentation over to Aaron and Dan. Welcome to today's event, gentlemen.
Thank you very much. It's our pleasure to be here, and we are excited to have this opportunity to speak to you and your members. So with that, we will jump right in. We'll start with a quick overview of what we're going to be covering today. We're going to begin with a discussion of drug testing laws in general to give everybody the lay of the land, because it's a rather interesting area that's different than quite a number of the other areas in which we provide services, and we'll get into that and explain why. Then we'll dive into a closer look at reasonable suspicion testing, since that's the purpose of today's webinar and the focus. We'll then move on to talking about the impact of state laws, particularly on marijuana legislation or marijuana laws. I think if anyone's been following the issue, it's certainly quite timely from what's going on at the federal level to the various states that are now legalizing either recreational or medicinal use of marijuana, and how that interplays with the workplace laws, because it certainly creates some interesting challenges that I suspect have perplexed or concerned a number of listeners. And then we will get into, we'll conclude with a discussion of OSHA's e-record keeping rule, which came out in 2016 and caused quite a stir with respect to what that meant for those employers that were conducting drug testing after accidents, after injuries, particularly those that were doing it on an across-the-board basis. So starting with the really three overarching questions that you may often ask yourself as an employer. First, can we legally require current employees to take drug tests? What can we do with respect to applicants? Because as you might have experienced or might imagine, there are certainly a number of differences in the laws that are out there as far as what you can do with respect to an applicant versus what you can do with respect to an employee. And if we're going to do those things, how can we ensure that we don't run afoul of the various laws? And I alluded to this before as far as some very significant differences between the drug testing laws and a various number of other employment laws. So instead of a comprehensive regulatory system, in this area, federal law provides for specific agencies to adopt drug testing regulations for those employers that are under their jurisdiction. So for example, the Department of Defense requires defense contractors to set up procedures for identifying drug users, including random drug testing. Similarly, if you have a fleet of trucks or vehicles and you have drivers, the Department of Transportation requires the industries that it regulates to conduct random drug and alcohol testing for workers in safety-sensitive jobs, as well as testing after accidents and when there is reasonable suspicion of employee substance abuse. Meanwhile, the Federal Omnibus Transportation Employee Testing Act requires tests for all operators of aircraft, railroad equipment, mass transportation vehicles, and commercial motor vehicles. And when you contrast this with OSHA, I think it's an interesting contrast because with federal, you've got your federal OSHA standards, and then the states are obligated, those that have state plans are obligated to have a system of rules and standards that are at least or impose the same requirements and rules as the federal system, or they have the right to go above that. And you don't have a system like that here. There is no federal baseline as far as what employers have to do or cannot do with respect to drug testing, such that the states can go above that. It really is kind of, and I'll get in, you probably hear this term again, a bit of a patchwork system of the various laws that are out there. And it can be quite confusing for those employers that have operations in a variety of different states. So we'll talk a little bit about the background here. The Drug-Free Workplace Act of 1988 requires some federal contractors and all federal grantees to agree that they will provide drug-free workplaces as a condition of receiving a contract or a grant from a federal agency. So if you conduct business with the federal government, that means that you may be required to enforce zero-tolerance policies regarding the use of illegal drugs in your workplace. Notably, the Drug-Free Workplace Act does not regulate drug use outside of work hours, nor does it mandate drug testing. All organizations covered by the Drug-Free Workplace Act are required, however, to first publish and give a policy statement to all covered employees, informing them that the unlawful manufacture, distribution, dispensation, possession, or use of a controlled substance is prohibited in the covered workplace, and specifying the actions that will be taken against employees who violate the policy. This is typically done through your company's employee handbook. Additionally, you must establish a drug-free awareness program to make employees aware of A, the dangers of drug abuse in the workplace, B, the policy of maintaining a drug-free workplace, C, any available drug counseling, rehabilitation, and employee assistance programs, and D, the penalties that may be imposed upon employees for drug abuse violations. There are also other requirements that we're not going to go into in detail now regarding notification to employees, notification to the contracting agency, and making an ongoing good faith effort to maintain a drug-free workplace. A contractor or grantee who fails to comply with these requirements may be subject to certain penalties, potentially even the loss of a contract. So as far as the legal concerns, since there is not this overarching system that answers all the questions or imposes all the regulations. Number of other factors to consider. So although the state in which your company is located may allow you to engage in drug testing, employees and applicants may still have legal claims based on who was tested, how the test was conducted, or how the results were used by the company. The violation of state laws and procedures, although an employer may have the legal right to engage in drug testing, it must follow the state requirements. So for example, in a number of states, including Maryland, an employee can bring a legal challenge against his or her employer if the employer did not have a legitimate business reason to test or did not provide documents that were provided following a positive test result. There's always the risk of a discrimination claim, so an employer who singles out certain groups of employees for drug testing by race, age, gender, or any other characteristic that is protected by law could face a claim for discrimination. And if you then dig down a level below that, there are just different types of discrimination claims. There's the concept of disparate impact, which is a neutral policy that impacts one group differently than another, versus disparate treatment, where you're specifically setting out to treat one group or one person differently than another. So we've seen claims on the disparate impact side, for example, where an individual claims that the policy of testing has a disparate impact on a certain racial group or potentially a different age group. You also have the risk of an invasion of privacy claims. So even an employer that is allowed to or required to test for drugs could violate employee privacy in a way that it actually conducts the drug test. For example, an employer that requires employees to disrobe or provide a urine sample in front of others could face liability for invasion of privacy. And then another claim, which is I often find is somewhat forgotten or overlooked by employers that are otherwise checking all the boxes, is defamation. So an employee might have a valid claim for defamation if the company publicizes the employee's positive test result, and that doesn't obviously mean in the newspaper or on social media, but just throughout the company to people that don't have a need to know. If a retest showed that the first test was a false positive or the employee appealed the first test, the employer could be liable for revealing the results of the positive test beyond those who have a need to know within the company. Since there is no comprehensive federal drug testing law for private employers, this leaves the field fairly open to state regulation, as I've said before. And if you look at, I said before, this concept of a patchwork, and look at the map here, as a general rule, testing is presumed to be lawful unless there is a specific restriction in state or federal law. However, the body of law on employee privacy and related issues continues to evolve, and any testing program that is not explicitly authorized should be considered open to legal challenge, or at least one that you want to research before you're rolling it out. Just to give you a flavor of the types of restrictions or the variations that are out there, I'm going to cover a handful of states here, just to kind of, again, go over what's out there. So in Arizona, testing is authorized, including random testing, for any job-related purpose consistent with business necessity. So then you have to ask yourself, well, what does business necessity mean? There are certain positions that perhaps you can demonstrate that there is a justification for testing those employees that hold it, others that it might not. Arizona also requires employers that are going to be engaging in testing to have a specific policy that covers the types of testing. In Connecticut, testing is authorized on reasonable suspicion of substance abuse. Random testing is authorized for employees only in safety-sensitive jobs. Idaho, testing is authorized, including random testing, but only after notice is given to the employees of the intent to have a testing program. Iowa law requires that the policy must list the types of tests that you're going to be used and state that violation is grounds for misconduct or discharge. In Iowa, you can test when there is probable cause to suspect substance abuse and the employee holds a job in which impairment would pose a danger, but you can also test during the annual employee physical. Maine is one of the more restrictive states out there, and while it authorizes testing if there's probable cause for suspicion of drug abuse, it has to be not based solely on the occurrence of an accident, meaning that the mere fact that someone had an accident does not necessarily create probable cause. Maine also has some very specific requirements as far as the preparation and dissemination of the policy. So if you have operations in Maine and you are planning to roll out testing, you definitely would want to consult with counsel that can advise through that process. In Minnesota, employee testing is authorized after an accident or part of an employee assistance program when there is reasonable suspicion of abuse or as part of an annual physical, provided, and I think this is interesting, that the employee has 2 weeks advance notice. Minnesota permits random testing for employees who are in safety-sensitive positions. As far as applicant testing, I think this is important to know. Generally, we find that applicant testing is subject to fewer restrictions, and more states allow it across the board. But be mindful of the fact that there are a number of states out there that require or limit the testing of applicants to the point in the application process after which you have extended a conditional job offer to the employee. There are also a number of states that have no regulation whatsoever with respect to drug testing of employees or applicants. Illinois, New York, and Michigan all do not have any regulation on the subject. And again, so just to summarize, the fact that your state may not have drug testing restrictions, again, does not give you carte blanche in terms of the decision whether and how to test for drugs. So again, you would want to look at whether there are restrictions as far as the type of notice required, the types of policies that you have to have, and what you do once the employee tests positive for drugs. Another consideration is presence of a union, obviously, and I assume that most of our listeners understand this, that if you do have employees that are subject or represented by a union, and that there is a collective bargaining agreement in place, that you're going to need to review the CBA but to determine if you have the ability to require or impose drug testing on the employees. If not, there's certainly going to be a duty to bargain with the union about this policy, and the failure to do so can result in an unfair labor practice charge against the company. So now let's talk a little bit about reasonable suspicion testing. So this is testing that is conducted after there's reasonable cause for suspicion of drug use, or being under the influence of drugs or alcohol while at work. Now, it's important to keep in mind that this is based on observable signs and symptoms, and that secondhand reports are not sufficient basis to proceed with testing. So if you have an employee who comes to a supervisor or a manager and says, "Hey, I saw Fred and I think he's high. I think he's drunk. You should test him." If you're not going to bring Fred in for a drug test or send him to a test simply based on that report from another employee. And you're going to want to be mindful, obviously, of you would want to get as much information from the reporting employee. What are the signs or indications that employee saw that led him or her to believe this and come forward with the report. At some point, if you have time, you might want to try to do some digging to figure out why the individual may have come forward to report this about Fred, if there was any history behind their relationship. But again, at least figure out what were the reasons this employee came forward, what were the things that this employee saw or heard before coming forward, and then take that information and proceed with it from there. So as far as this process, it really is something that there are multiple aspects to a reasonable suspicion testing program. This is not something that you're just going to pull off the shelf and roll out tomorrow. First, you would develop and disseminate a policy in addition to the specific policy that is provided to the employees. Generally, you will want to have some sort of procedures or guidelines that the managers who are responsible for enforcing the program as well as the anyone in human resources or operations is going to have at hand. In other words, a procedures manual, something that they could consult. That may not necessarily be what is given to the employees, however. That only needs to be the simple policy that explains the program. To the extent that you are relying on your managers to carry out the policy or either to conduct reasonable suspicion analyses before referring the person to a test, you're going to want to train your responsible managers, whether that's done with a third-party provider or you have one person who gets the training and then train the trainer training and then provides it to all your managers. There are no requirements as far as how that is done. You just want to make sure that everybody is fully trained and understands their role within this program. As I said before, and I'll get into this a little bit more, observation and documentation. If you've ever listened to any webinar or seminar presented by lawyers, you probably heard the emphasis on documentation. You should always assume, particularly with something like this where the stakes are high, where somebody's job or livelihood is potentially on the line, that there's a good chance that they may pursue some sort of remedy, whether it's through a state agency or through litigation. And as I assume many people realize or understand, that something that you do today or tomorrow, if you don't document it, there's likelihood that memories will fade and that people are not going to remember what was done, why it was done, or certainly even be open to challenge that it was done in the first place. Once you've observed and documented the potential impairment, then you're going to notify the subject employee of the findings. At that point, then you're going to confirm whether the individual consents to the testing or if they're going to refuse. And then that, again, documenting each of those aspects to it. Then there's transportation to the testing location. There's the specimen collection, and then notification of the results. So as I said before, we start at the point where we're assuming that a report has been received by a supervisor or manager, and you're not going to rely on the report from a third party, an employee, a contractor, whomever. Once the report is received, the receiving manager or supervisor should personally observe the individual and then complete a checklist. Our recommendation is that companies have a checklist of the different indicators of potential impairment and use that to guide them through their analysis. If the individual who performs this initial observation of the employee concludes that there does indeed appear to be reasonable suspicion, at that point, the best practice is to involve a second supervisor or manager and have that person then observe and document the subject employee to confirm that they too see the same things. It's the same thing as I think in a termination meeting when you want to have a witness. Two people are always going to be better than one when they are both in agreement and can both report the same things. Assuming the two supervisors or managers are in agreement that there is a potential violation, they should notify human resources. As I said before, if there is a union involved here, just as you're going to want to notify the union steward or the business agent, whomever is on site, as to the findings. And when I say here in the last bullet point, stay together, obviously that's not necessarily always and entirely possible, but during these interactions, both with the union, if there is one, as well as with the employee, you want to be together as much as possible. So there always is a witness who can talk about what happened, what was said, particularly if the employee makes an admission or asks a question about his or her rights or the procedures, and an answer is given. You want to make sure that there is somebody there who can attest to either what was heard or what was said to the employee or by the employee. Once the employee is notified or in the process of notifying the employee of the possible violation, you want to share with the employee what was observed and explain specifically why you've reached the conclusion that that there is reasonable suspicion, and then ask the employee for an explanation. I always tell employers that even if you're absolutely convinced the guy reeks of marijuana or he smells of bourbon or whatever it is, you never know what the explanation is. I recall once filling my car up on the way to the airport and with a rental car, and gas spilled out of the tank and it got in my clothes, and I was thinking, well, what happens if TSA asks me why do I smell like gasoline? I think I had a pretty good explanation. Maybe they would have expected that one, but there are times where employers you may have no idea, or never in a million years would you guess what the explanation is, and they may have one. More often than not, they're not going to have one. And when they don't, that's when you let them know that their explanation is not sufficient and that you're going to proceed with testing. And at that point, you then ask the individual to consent to the test. Assuming that they do, you give them a consent form and you ask them to sign the consent form. Now, if in the event that the employee refuses to sign the consent form, you don't want to just proceed, just stop the process and call it a day and then proceed with the next step in terms of consequences for refusal. I recommend that you ask a second time, and that in doing so, that you confirm what the consequences are for refusing, reminding the employee whatever your policy provides. If assuming refusal results in suspension pending termination, then make sure the employee understands that, and have if possible, if they acknowledge that, yes, I understand that, and put all that. Make sure you document that in your notes as well. At this point, since the individual is presumably refusing to consent to the test and go to the testing location, that means that you can't let them return to work now that you've made the determination that they are impaired. So that means they need to go home. And at that point, you want to instruct the individual to make arrangements so that they can travel home safely. This is not a house party where you're going to forcefully take their keys away. So if they say, no, I'm fine, I'm going to drive, I would sternly suggest to them, no, that we do not want you to drive. We believe that you're impaired. And if they refuse again and say that no, they are going home, at that point, if you have information about their car or their vehicle, it would be a recommendation to contact the local authorities and indicate that an employee whom you believe to be impaired has left the premises in his or her own vehicle. I would also recommend that you notify Human Resources or any other entities that would in your organization need to know about this. So whether that's risk or legal, let everybody know what has happened, that you have an employee who appears to be impaired who has taken their car or their truck to head home. Assuming instead that the employee has agreed to proceed with the test, and the forms have been filled out, send the forms ahead to the testing location. And at that point, again, just as hopefully the two managers or supervisors have been together at this point, that they will jointly transport the individual to the collection site, remain at the collection site during testing, while the employee is undergoing the testing. There may be times where questions come up regarding medical impediments to testing, or any other conduct that may be deemed or viewed to be as a refusal. And if that's the case, then you would want to have both managers or supervisors there to address those issues. Once again, don't need to repeat this, but the same rules. Once the testing is completed, you want to remind or instruct the individual to make arrangements to travel safely home. And again, if they refuse, to go through that same process. So with that, I'm going to turn it over to Dan to cover the next couple sections.
Great, thanks, Aaron. This is Dan Deacon now, and I'm going to begin here with another pretty big legal topic when it comes to drug testing and drug use, and that is the Americans with Disabilities Act. And this is an area of the law that does have some interplay with drug use and drug testing issues. So we wanted to give you an overview of how the ADA and drug use, drug testing interface, and some best practices to avoid ADA discrimination claims. So first, drug testing is allowed under the ADA. That's because the ADA does not consider drug abuse a disability. However, disability discrimination is by far the most significant legal risk when deciding whether to engage in drug testing. So the ADA provides that a person using illegal drugs is not a qualified individual with a disability under the Act, and thus they're not protected. In addition, testing for illegal drug use is not considered a medical exam. So the ADA does not restrict when an employer can test for the use of illegal drugs. Remember, federal law doesn't require or prohibit drug testing, but employers with 15 or more employees are required under the ADA to have at least a conditional job offer on the table first before requiring that applicant to submit to a pre-employment drug screen. Finally, I also want to point out that although illegal use of drugs is not covered under the ADA, alcoholism is considered a disability. So if you do encounter a person that has alcoholism, it's important to tread carefully when making employment decisions related to that employee, especially if they've informed you that they have alcoholism. So as I mentioned before, disability discrimination is by far one of the most significant legal risks when deciding whether to engage in drug testing. If an employee is fired or an applicant is denied a position because of a positive drug test and his or her medication was legally prescribed for a disability, the employer could be liable. So some prescribed medications turn up on drug tests, and some drugs that would otherwise be illegal, such as opiates, are legitimately prescribed for certain conditions. So that goes back to what Aaron was saying just a few minutes ago, that the employee may have a legitimate explanation for a positive test, and this is one of those scenarios. Therefore, you shouldn't just assume that because an employee didn't pass a drug screen that they're abusing illegal drugs, or that it's grounds for termination or some other employment action. It's critical here to keep in mind that the ADA reasonable accommodation obligation applies at application, hiring, and during employment. So employers are required to make a reasonable accommodation to allow individuals with disabilities to apply and be considered for jobs, so long as that accommodation does not cause undue hardship. And that includes accommodations in connection with pre-employment drug testing processes. So keep in mind, it's common for plaintiffs' attorneys to launch these copycat litigations and file these claims after the EEOC files lawsuits over particular employment issues, and we're going to cover a couple of those in some of the following slides here. But as a result of the cases that have come up recently, we kind of expect to see an uptick in private litigation if employers don't utilize some flexible hiring procedures or don't otherwise have ADA compliant hiring practices. And the cases that we'll highlight here kind of emphasize that, and some of the cases involving marijuana use especially, you'll see a myriad of different decisions, and the state laws vary on how those apply. So it'll be interesting to discuss this shortly. So here we're going to start with two recent lawsuits that highlight the ADA concerns surrounding drug tests. So the first one here involves Kmart, and this case highlights the potential need to make an accommodation for drug testing. So in this case, the employer Kmart here revoked an offer because the employee or the applicant couldn't provide a urine sample for drug testing. And the applicant actually had a kidney disease and was undergoing dialysis. and he expressed a willingness to take a different type of drug test. He just couldn't take the urine test, so he proposed a hair or a blood test. Kmart denied that request and insisted that all new hires needed to complete that standard urine drug test that was provided at its facility. So the EEOC filed a claim against Kmart, arguing that its drug testing policy ran afoul of the ADA. We didn't get a decision from a court on that case because it ultimately settled for $102,000. But Kmart also agreed to revise its alcohol and drug-free workplace policy and its pre-employment drug testing policy. And that included a description of its obligation to provide a reasonable accommodation to employees or applicants in this testing process. Another notable case involves Walmart, and the facts are actually quite similar. So Walmart had offered an applicant a sales job and required her to take a pre-employment drug test. And the applicant said that she had end-stage renal cancer, which prevented her from, again, taking a urine test. And the plaintiff, or the applicant, allegedly requested another type of test similar to the Kmart case, but she was told that corporate wouldn't allow that alternative test. As a result, the EEOC ended up suing Walmart for a violation of the ADA. And again, this case ultimately settled, so we didn't get a decision. And Walmart agreed to provide 90 minutes of manager training on the accommodation process and to post notice to all store employees. And they also agreed to provide notice to applicants of alternative specimen testing. So these are just two examples of cases highlighting the reasonable accommodation process as it relates to drug testing and the importance that you have some flexibility in those processes, or you could end up in court or facing a lawsuit by the EEOC or a private litigant. Again, as I mentioned, private litigants tend to take up a lot of these claims after the EEOC brings this type of litigation. So now we're going to cover some of the marijuana laws and how employers need to carefully navigate the myriad of laws across the states that may apply to them, especially large employers, of course, that operate in multiple jurisdictions. So to begin, let me step back one here. So marijuana is considered a Schedule I controlled substance under federal law, and that's the Controlled Substances Act. So under federal law, marijuana is still illegal. And as you're all probably aware by this point, marijuana is not illegal under several state laws, almost a majority to some extent for medical purposes. So 29 states in the District of Columbia have legalized marijuana use, at least for certain medical conditions. And then there's 9 states and the District of Columbia that have legalized marijuana for recreational use. So no doctor's letter or prescription card required. And those are typically for adults over the age of 21. And there's currently, I believe, 3 other states that have bills pending and proposals to legalize marijuana, and that is West Virginia, Ohio, and Texas. Over the next few slides here, I want to talk about a couple cases where the courts found disability discrimination under state law, despite marijuana being considered illegal under federal law. And the first case here comes out of Rhode Island, and that was Callahan versus Darlington Fabrics Corporation. So there, the Rhode Island chapter of the ACLU, the American Civil Liberties Union, they filed a lawsuit on behalf of the plaintiff back in 2014, alleging that her rights were violated through unlawful discrimination. So she was a grad student in Rhode Island, and she had a prescription for medical marijuana, and that was to treat her migraines. And it appeared that she was going to have this internship until during the meeting she disclosed that she used medical marijuana to treat her condition. She also said during that interview that she wouldn't bring drugs with her into work or show up ever after having taken the drug, after having used the marijuana. So a few days went by, and the company contacted her and told her that she wouldn't be getting the internship. She wasn't offered it, and that was because of her status as a medical marijuana patient. So just some background on the law in Rhode Island. Rhode Island's medical marijuana law has specific anti-discrimination provisions. And under that law, employers can't refuse to employ or penalize anyone solely for their status as a medical marijuana card holder. So this is a different theory than violation of lawful off-duty conduct laws or disability discrimination under the ADA. This suit was pretty much the first to invoke the anti-discrimination provisions of a marijuana law. So it was unique in that it presented the court with an opportunity to address head-on the anti-discrimination provisions of the state statute. And what happened here was the court held that the act created an implied private right of action, in large part because without such an implied private right, the law's prohibition on refusing to employ a person solely because of their status as a marijuana card holder, a prescription card, it would be rendered meaningless. So the court agreed that employers aren't required to tolerate employees who report to work under the influence of marijuana. It held that the act expressly states that an employer can't refuse to employ a person due to his or her status as a card holder. So the court ruled that the employer violated the state statute in refusing to hire her, even though she admittedly couldn't pass that pre-employment drug test. Other states have anti-discrimination provisions as well. It's not just Rhode Island. And those states include, for example, Arizona, Delaware, Connecticut, Illinois, Maine, and Minnesota. So employers with operations in those states need to be wary of this case and those anti-discrimination provisions explicitly laid out in those state statutes. The second case here comes out of Massachusetts, and this is also a pretty interesting one. It's Barbuda versus Advantage Sales and Marketing, and there medical marijuana was being used at home to treat Crohn's disease. And the employee was fired from a marketing position after failing a drug test, and then he claimed disability discrimination in violation of the state law. And the Massachusetts Supreme Court reversed dismissal and rejected the employer's claim that use of illegal drug made accommodations facially unreasonable under the state law. So the company could prove undue hardship by showing the use of marijuana by an employee would violate the employer's contractual or statutory obligation and thereby jeopardize its ability to conduct its business. So what happened here was the court held that the plaintiff was disabled and basically rejected the employer's claim that her use of marijuana, an illegal drug under federal law, rendered the accommodation facially unreasonable under the state law. So in doing so, the court relied on language in that state statute prohibiting the denial of any right or privilege on the basis of medical marijuana use. And the court further explained that where a handicapped employee needs medication to alleviate or manage the medical condition that renders her handicapped, and the employer fires her because company policy prohibits the use of this medication, the law does not ignore the fact that the policy resulted in a person being denied employment because of that handicap. So going on to recreational marijuana, and this is an area of the law that is, causing some concern for employers and raising a lot of questions. And as you can see, there's 9 states and the District of Columbia, so 10 jurisdictions that have legalized recreational use of marijuana for individuals 21 and over. And the purpose here is they're decriminalizing marijuana for recreational use with restrictions that are basically similar to alcohol. So like laws concerning alcohol, they failed to create specific employee rights or clarify employer obligations. So the area of law here doesn't really touch on employment law, and it's kind of a gray area. And it's so new, most states haven't really had an opportunity for judicial interpretation. It hasn't really come through the courts yet. So what that means is that there's little, if any, guidance about what the statutes mean, much less a clear distinction for employers that are trying to grapple with how their policies and practices should be modified and take into account these new statutes. And I should add, compounding that confusion is still the federal law, which makes marijuana illegal. So one of the big overarching questions for employers that we often receive is whether an employer can lawfully impose discipline, including termination, on an employee who tests positive for marijuana. And as you see on the slide here, this is what some people think of as the classic lawyer answer, but it depends, and that largely depends on the state in which you are located. With that being said, however, the answer is generally yes. Employers can discipline and terminate an employee who tests positive for marijuana. So most states allow employers to prohibit the use of marijuana on the employer's premises, as well as any on-the-job intoxication. So going back to what Aaron was talking about at the beginning of the presentation with the reasonable suspicion inquiry, if you have reasonable suspicion that someone is high at work or intoxicated and you have that firsthand account of it, you should certainly have reasonable suspicion and grounds for a drug test in those scenarios. And there's some case law supporting the employer's right to terminate when an employee tests positive. So that is pretty well documented in the courts. So another, one of the big questions is, can an employer discipline an employee for off hours and off-site use or influence of marijuana? So, and that's two sub-bullets here. One, when it's pursuant to a valid prescription. So those are in medical marijuana states. And then the second piece here is, what about off hours and off-site recreational use? Those in recreational states. So remember, in some states like Arizona, Delaware, Minnesota, I think, and the case that we discussed, Rhode Island, the statutes expressly prohibit employers from terminating an employee for a positive marijuana drug test if that employee holds a valid marijuana prescription card. In contrast, some other states like Colorado, California, Montana, Washington, some of the states on the West Coast, Oregon, existing statute or case law in those jurisdictions direct that employers can lawfully implement zero tolerance policies, regardless of the legality of marijuana under state law. With that being said, as marijuana laws continue to evolve and expand, these laws could be reconsidered, especially with the uncertainty and the growth of recreational use and more states passing marijuana laws. And with respect to the second question about off hours and off-site recreational use, what is normally considered off-duty conduct, right? It really just depends, but generally these laws don't protect employees from being fired due to off-duty marijuana use. So in fact, many of the laws expressly state that they don't affect an employer's right to continue to enforce those zero tolerance policies. The one state, I guess, which is pretty interesting and worth pointing out here is Maine. So, for example, in Maine, workers no longer actually have the right to worry about getting in trouble at work for smoking marijuana in their off time. Employers can't discriminate against employees for using medical marijuana or marijuana byproducts outside after new laws went into effect, and I think it was within the past year. And the state's labor department, Maine's labor department, has removed marijuana from its list of substances that employers can test applicants for. So individuals who use marijuana during work hours and at the workplace, however, can still be disciplined by their employer. It just is related to those applicants. You can't be testing applicants for marijuana use in Maine. So despite the example I just went through there in Maine, this case right here, Coates versus Dish Network, and many of you have likely heard of this case out of the Colorado Supreme Court. This provides the majority approach regarding off-duty use of marijuana and how that interplays with zero tolerance policies. So there, the employee was a paraplegic. He was in a car accident when he was a teenager, and he had a licensed medical marijuana card at the time he was working at Dish Network's call center, and the company required him to take a drug test, which he of course failed. And he was then terminated because Dish had a zero tolerance policy. So Coates brought an action for wrongful termination under Colorado's lawful activities law, which basically prohibits employers from firing employees for engaging in illegal activities while not at work. Coates, the plaintiff here, he claimed that his position was not hazardous. He wasn't in an executive position that required decision making, and perhaps most importantly, he was never under the influence of marijuana during work time or on company premises. His use of the medical marijuana was strictly at home, and it was never, as I mentioned, brought into the workplace, and he never used it during or before work. He also claimed that Dish knew of his status as a medical marijuana patient when he was hired, and that made their claims of a zero tolerance workplace invalid. So Dish, on the other hand, asserted that it was entitled to enforce that zero tolerance policy, and in any event, even though marijuana was permissible under state law, it couldn't be considered lawful off-duty conduct due to its status as a controlled substance under federal law. And the Colorado Supreme Court ultimately upheld the decision of the trial court for the employer and found that its termination decision was lawful. So this is an example of those zero tolerance policies being upheld in court despite state law permitting employees to use marijuana for medical purposes. So this slide goes over a couple practical aspects to consider, and here's 3 questions a lot of times that employers are asking themselves given the rise of these medical marijuana laws and the recreational use laws. So first, will a zero tolerance policy on marijuana reduce my pool of qualified candidates to an unacceptable level? 2, will failing to test for marijuana increase workplace injuries or absenteeism? 3, will treating marijuana differently than other illegal drugs create problems in my workforce? So initially, while a zero tolerance policy on marijuana may reduce the level of qualified candidates, especially considering 15% or so of Americans do smoke marijuana, according to certain studies, and that's quite a large number. That's a large share of the population here. So perhaps you do lose out on some of the candidate pool that would be qualified, and they could be good employees. Given those concerns, a lot of employers are softening their zero tolerance drug policies, particularly for jobs where safety isn't an essential function. And these state laws allowing marijuana use, they're kind of complicating recruiters' efforts to find drug-free employees. And low unemployment and increasing use of drugs are certainly narrowing the pool of qualified workers in a lot of regions, especially those states that have had medical marijuana laws and recreational use laws on their books for quite some time. So before relaxing your zero tolerance policies, it's certainly a big step, and it's something you need to get buy-in from company leadership and make sure that they support that movement, and you really need to narrow what type of policy that you want and how to deal with the consequences arising out of that policy. So next we're going to go into OSHA's anti-retaliation elements of its electronic injury and illness record-keeping rule, in particular how those affect post-incident drug testing. So as background and just high-level overview of the rule, on May 12, 2016, OSHA published the final rule, and there were two major provisions. There's the reporting element and then also the anti-retaliation piece. As it relates to the reporting element, establishments with 250 or more workers annually need to submit their OSHA 300 logs, 301 incident reports, and 300A annual summaries. And establishments with 20 or more workers in high hazard industries were required to annually submit 300A annual summaries. That July 1st reporting deadline for 2018 is coming up, and all establishments, regardless of your employee count, are only required to submit 300A summaries. That reporting requirement alone is certainly more detailed, and there's plenty of information that could take up an entire webinar itself, but we'll leave the reporting piece at that. So on to the anti-retaliation piece. OSHA included a couple anti-retaliation provisions, both directly in the regulations and in the preamble to the rule, which we're going to focus on here. So as of December 1st, 2016, employers are required to 1, inform employees of their right to report workplace injuries, 2, inform employees of their right to report work-related injuries free from discrimination or retaliation, and 3, update internal injury reporting policies to remove unreasonable elements. And how does this affect drug testing laws? Well, that was included in the preamble to the final rule. There's a pretty lengthy discussion in the preamble, and the post-incident drug testing was largely limited, and it explicitly prohibited blanket post-injury drug testing policies. In other words, you can't just test an employee following an incident or injury unless you have reasonable suspicion that drugs caused or may have contributed to the injury or incident. So OSHA's justification for these new rules was that drug testing could dissuade reasonable employees from reporting work-related injuries because of invasion of privacy issues. But the overarching concern was post-injury drug testing being a form of discipline. So post-injury drug testing, blanket post-injury drug testing policies are prohibited, but that did not, the rule itself did not touch on other forms of drug testing. And here's just, a list of five permissible drug tests under the rule that are still perfectly valid. Pre-employment drug testing, random drug testing, to comply with state or federal law, such as Department of Transportation mandatory post-incident tests when it's required by a workers' compensation insurer. And then finally, the standard that came out of the rule, likely when drugs likely contributed to the injury and where the test can identify present impairment. So given that a post-injury or post-incident drug test needs to be based on this specialized inquiry, these are a couple of the other types of drug tests that you can perhaps supplement and continue to roll out in your policies, especially random drug testing. With that, I'm going to turn it back over to Aaron, and he's going to continue on with some of the OSHA rules.
Thanks, Dan. And I think a little bit of background helps to illustrate or let everyone understand where OSHA is coming from with this rule, because as I alluded to at the beginning, it's definitely created quite a bit of I guess consternation and upset on the employer side. For years now, every year when I attend the American Bar Association Occupational Safety and Health meeting every spring, there historically have been representatives from the union side who take a very dim view of of post-accident drug testing. And as Dan said, they truly believe it, or at least they say that they believe that it is done as a way to intimidate and to I guess, as Dan said, discipline employees. And one of the leading voices on this side was the representative of Change to Win, which is a coalition of various labor unions that popped up about 12, 13 years ago as an alternative to the AFL-CIO. And I suspect both in public and in private that they lobbied the federal government and pushed for this rule. And so understanding where it's coming from, as far as these unions know that a number of their members are using drugs, whether it's the medical marijuana or the recreational marijuana that Dan talked about, or opiates or other things, and they've been particularly concerned that the companies are using the threat of a drug test to punish these individuals for, whether it's from their perspective for unions, what have you. So the point of the process is, when you're looking at rolling out testing or conducting post-accident testing, how do you do it in a way that can meet the requirements of OSHA's rule that Dan's talked about? One thing is you can use it as a tool to evaluate the root causes of workplace injuries, which is a relatively benign reason. It's not being used for discipline. It's being used to help make the workplace a little bit more safe. If you are going to use it for disciplinary purposes, for potentially to terminate an individual, the expectation from OSHA is that it is done in a way to determine if drugs could have contributed to the accident or the injury that took place here. So what criteria, or first aspect, is whether the employer had a reasonable basis to conclude that drug use could have contributed to the injury. The next is whether other employees involved in the incident or accident were also tested. I think that's a fairly obvious one. Hopefully, if several individuals were operating a piece of equipment and only one individual is tested, you will need to have some explanation or justification for only testing one person and not the other. Obviously, if one person was working appropriately at their workstation and they were hit by a fork truck that was careening out of control because someone was driving recklessly, you could justify or explain why you didn't test the person who was hit, but you tested the person who was operating the powered industrial truck. Number three is whether there's heightened interest in identifying drug use because you are operating, you exist or operate in a high hazard field. And third, whether the drug test is capable of measuring impairment at the time of the injury. Now, that obviously really only applies to alcohol tests, because at least as the time of this webinar, there really hasn't been any sort of testing that has been developed or designed that can test impairment as far as marijuana or most other illegal drugs. Now, moving on, slide, okay. So now I think the examples that OSHA gave as part of when this rule was rolled out to illustrate when testing would be appropriate versus not appropriate, I think are interesting. So this one example, crane accident injures several employees working nearby, but not the crane operator. You don't know the cause of the accident. but perhaps it was caused by the crane operator making an error, the spotter, the rigger. So reasonable to test all employees whose conduct could have contributed to the accident, whether or not they were injured. If you're only testing the injured employees, you're going to have a problem. Testing employees, if the reasonable possibility exists that drug use caused the accident, can provide, again, as I said before, insight into the potential root cause, but it would not be reasonable to test only the injured employee. Another example that OSHA gave, which I found to be a little bit troublesome or potentially a little short-sighted, was, well, an employee is stung by a bee, and so you wouldn't test an employee who is stung by a bee. If you do, that's perhaps retaliatory because he or she reported the injury. But I think there are scenarios, even something as simple as that. Perhaps if the employee is taking the trash out as part of his or her job and is stung by a bee in the trash can, yeah, I don't think you would test that employee. However, if the employee is a maintenance worker and is cleaning out an area or doing some sort of maintenance, and the investigation suggests that there's a giant hornet's nest hanging there that anybody who was not stoned out of their mind would have seen, I think you might be able to justify testing that employee. So what it really boils down to, hopefully, as you can kind of see from the different examples, is you should be conducting a case-by-case analysis of each situation, and to determine whether or not the use of illegal drugs or alcohol could have contributed to it. I tend to maybe fall a bit on the more aggressive side, and if there's any potential way that the drug or alcohol use could have contributed to it, then I would say go ahead and test, and maybe reserve not testing only for the most very clear cases that it could not have contributed to the accident. At the end of the day, as long as you have that process of going through that analysis, I think you're going to be in fairly good shape if the agency were to look into your testing practices. I would also say, though, that if you're testing people who report repetitive stress or strain injuries, that obviously, or certainly, I would struggle to come up with an explanation as to how we think the drug testing could have caused a repetitive stress or strain injury. Those are the ones that are going to be particularly problematic or troubling. So, for those of you that are safety nerds like us, who follow the status of this e-record keeping rule on a daily or weekly basis, you may or may not know where the law is in the process. The OSHA is actively pursuing violations, but only where there has been an aggrieved employee, and we're not aware of any citations being issued yet. When industry challenged this law towards the end of the Obama administration, the Department of Labor filed a motion to dismiss that challenge. But that has, after the inauguration, that challenge was, or the Department of Labor, I should say, withdrew the motion and the case was stayed pending the issuance of a new notice of proposed rulemaking. And that rule has now been sent, the revised rule has been sent to the Office of Management and Budget. It was sent about 3 weeks ago, and generally it takes about 90 days to go through the process once the proposed rule reaches OMB. So I think we should expect to see the revised rule at some point during the summer. What we're expecting to see, and as Dan said, you could cover a whole program on the reporting piece of this. In fact, we have. Go to our little shameless plug, our website. We've done webinars on this in the past, if you really want to dig deeply into the subject. One of the interesting things that caused a bit of controversy as well is what would happen to all the data, the reports that are uploaded to the agency. Would that data be available to the public? Would it be searchable, downloadable, exportable? Could people use it for their own purposes, whatever that is, in terms of PR or competition? Under the prior administration, it looked like that many of the answers to those questions would be yes, that it would be in a searchable format. We don't know what's going to happen. I suspect that it will be much more of what would be, I guess, called a data dump, and that people would have to sort through it. but we're not really quite sure. There is a lawsuit that was filed by Public Citizen challenging the lack of access to this data. Right now, the agency is stating that they intend to keep it private for 4 years. So anything that is submitted, the record keeping data that is submitted will remain private for 4 years. And most interestingly, I think many of us that have been observing and following this issue expected that the aspect dealing with drug testing, as well as with the incentive compensation plans that might be tied to safety behaviors or safety records. Probably go back 6-8 months ago, we all assumed that those would be removed from the revised rule, and there would be no reference or nothing in the rule addressing these aspects of employer procedures. But looking at or listening to remarks that Secretary of Labor Acosta has made, signal at least in some sectors that the drug testing part may remain in there. It wouldn't surprise me to see it out, but I think it's quite possible that it will remain in. Also, for those of you that have been following the comings and goings at OSHA, you would know that there is no Assistant Secretary of Labor yet in place. There has been someone nominated, and it's Scott Mugno, who's the former VP of Safety from FedEx Ground. He has cleared the first committee in the Senate, but has yet to come to a vote on the Senate floor for full confirmation. So we don't know. Obviously, if Mr. Mugno is in place, we might have a better sense of how the agency is going to enforce this rule going forward, but we don't. So with that, Mike, I don't know if we have any questions or time for it, but that is it for our presentation.
Thank you, Aaron, and thank you, Dan. I've got just a few questions for those that have a moment to be able to stay on. I have 3 questions here, and I'll leave it to you, Aaron or Dan, to answer them. The first question I have here is, if I need to send someone in for reasonable suspicion testing, do I need someone of the same gender to drive that person to the testing facility? And a follow-up to that is, what if that isn't possible?
I can handle that one. Dan, feel free to jump in. I mean, for the driving part, I don't see gender being particularly relevant or important. I think particularly it could be difficult to always have, if we're going to have 2 supervisors driving, making sure both of them, presumably any interaction with the employee being tested that is sensitive or private should be done by the testing facility, and that they will have individuals of the appropriate gender available.
Thank you for that. Second question is, what if the person or persons trained in reasonable suspicion at our facility are not available when a potential substance abuse problem is brought to management's attention? How should we respond?
I'll chime in on this one here, Aaron. So I think what you want to do is make sure that all managers and supervisory staff do have training on reasonable suspicion. And if an incident does occur, I assume that it would be immediately reported to someone in HR, safety and health, and they would be able to assist in making that inquiry if someone from management or a supervisor is not present at the site. So there should be at all times someone that's available to make that determination based on the facts that are provided from people that are there on site.
All right. And
hey guys, just wanted to point out, I did just post somebody's question in the chat box. If you could make sure you see that one, please.
Okay. Mike, did you have, I think you said you had 3 questions before we get to the last one.
Yeah, the last question I had here was, if I find drugs or alcohol in the facility but do not know who they belong to, how do I go about addressing that situation with my workforce?
So, I think that this is a good scenario. This scenario is one where you would look to and hopefully or consider rolling out some random drug testing, assuming that you are in a state that allows it, obviously. Again, I talked during the beginning of the program that there are a host of states that prohibit random testing or limit random testing to safety-sensitive positions. But even if you're in that the latter state, you could certainly at least then test the folks that are in random or in safety-sensitive positions. I think that would have something of a deterrent effect in keeping people on their toes. And aside from the testing angle, I think a good old-fashioned workplace investigation, depending on where the drugs were found, what shift they were found on, the traffic through that area. Do you have video, any surveillance video that might show who went into the area? And it could lead, perhaps you start with some interviews. You have to be mindful, I think, of the impact of how disruptive would a major investigation be? What quantity of drugs was found? Have you had any accidents lately? There are a whole host of factors that you might look into to determine, what sort of resources need to be deployed to address an issue like that. But certainly, I think you want to do something. You want to, again, to send the message to employees that that's not tolerated, but also just in terms of potential negligence claims or does your workers' comp carrier deny a claim down the road for some reason because they think that you willfully ignored the rampant drug use? I don't think that's likely, but it's something to consider.
I appreciate your answers. And the final question we have here is, do I understand correctly that for a company with an office in Delaware, an employee who is, for example, in an administration role where they sit in the office the majority of the time, who holds a medical marijuana card cannot be fired for testing positive? And then a follow-up to that is, what about an employee at the same company who drives and holds a U.S. DOT card?
Sure. So the Delaware law prevents employers from discriminating against an employee in hiring, termination, or any term or condition of employment, or otherwise penalizing that person for their status as a medical marijuana card holder, or because of a positive drug test for marijuana. So the law itself, though, does qualify those protections in two ways. So first, if the statute exempts employers from compliance if it would lose monetary or licensing related benefits. So for someone that has a DOT card, that could be an example right there. If it's for compliance with federal law. Second qualification there. What is the second qualification?
Yeah, and keep in mind also that certainly the DOT angle. The federal law will trump the state law in that case. And so if you have employees that are performing work subject to the DOT regs, then you would be adhering to and following whatever the DOT requires you to do with respect to their drug test results, their driving records, et cetera. So you would not, the Delaware law will not override or trump the federal DOT regs.
Right, and that second qualification is employers can still terminate an employee if they show up to work high or they bring drugs onto the premises. So if the employee in Delaware with a medical marijuana card does come to work high or brings those drugs on the premises, you certainly have the right to terminate them.
And that, just to kind of bring it, maybe tie it all up in a bow, that we talked earlier about people engage in lawful off-duty conduct in states that prohibit obviously the use of marijuana on company premises. I think, as Dan's pointing out, that if someone starts work at 8:30 in the morning and they smoke either in their car on the way to work or at home before they left, such that they are impaired when they get to work, obviously the laws are not going to extend the protections to them simply because the drug was not used on premises if they are impaired, as Dan said, when they get to work. And that's where you then kind of default back to or go back to the reasonable suspicion testing part of the program and initiate that process. And if you make the observations based off of the checklist, et cetera, then you can proceed from there.
Well, thank you, Aaron, and thank you, Dan. Great information there. Good answers to those questions. And I want to thank everybody for attending today's webinar. In the near future, you will receive an email directing you to a replay of the webinar and the associated documents. Also, watch your email for announcements about future webinars. And be sure to visit the ASA website at www.asa.net. We thank everybody and appreciate your participation in today's webinar on reasonable suspicion. Have a wonderful day, everyone. Thank you.